Okay, well, according to my clock, it's time to start, so I'm going to start. Good evening. This is ITMS 478-578, and tonight we're going to talk about legal, ethical, and professional issues. And when we complete this lesson, students should be able to differentiate between law and ethics, describe the ethical foundations and approaches that underlie modern codes of ethics, and describe responsibilities related to the handling of information about vulnerabilities, identify major national and international laws that relate to the practice of information security, list applicable laws and policies related to cyber defense, describe major components of each pertaining to storage and transmission of data, describe what the laws mandate and where they apply, and list applicable laws for compliance in a given situation. Should be able to describe how the type of legal dispute, civil, criminal, private, affects evidence used to resolve it, and describe the impact of legal regulatory standards on a given system. And finally, conduct audits to determine compliance with laws. That one's stuck in here. It actually belongs in a later lesson. Also discuss the role of culture as it applies to ethics and information security, and be able to access current information on laws, regulations, and relevant professional organizations. So it's a lot of objectives. That's not unusual in this course. So by way of introduction, all cybersecurity professionals need to understand the scope of an organization's legal and ethical responsibilities. This is necessary in order to understand the current legal environment. This is necessary. Let me back up. Basically, this is a necessity because you need to be able to minimize liabilities for the organization you work for. And in order to ensure that a cybersecurity professional is properly pursuing this area of their duties, you need to be able to understand the current legal environment in which you are operating. Need to keep apprised of new laws, regulations, and ethical issues as they emerge. Need to minimize the organization's liabilities and educate employees and management about legal and ethical obligations and the proper use of information technology and cybersecurity. So cybersecurity professionals and managers who are involved in information security have to possess at least a rudimentary grasp of the legal framework within which their organizations will operate, because the legal environment influences the behavior of every organization depending on the nature of the organization and the scale in which it operates. All management, especially cybersecurity professionals, are expected to act in compliance with legal requirements when collecting, storing, and using information. Remember that there is a saying in American law, ignorance of the law is no excuse. So if you violate the law and you didn't know about it, that's not an excuse, unless you're a cop. Then it's okay. So I have a disclaimer here. I am not a lawyer, nor do I play one on television. This lecture does not constitute legal advice, nor are there any guarantees or warranties as to the legal validity of any material included herein. The aforesaid statements may or may not be enforceable depending on the jurisdiction, the day of the week, the direction of the wind, the relative humidity, anything else, your shoe size. So, legal disclaimer. When you deal with lawyers, you always have legal disclaimers, right? So let's talk about law and ethics in information security. Laws are rules that are adopted and enforced by governments to codify expected behavior in modern society. So basically, they are essentially someone who says, hey, people should behave like this. People should not do these things. And they say, okay, let's write it down and make it enforceable. By the way, anytime anybody tries to tell you something is the law and they can't provide a citation, it's not the law. I'm working with somebody who's having a little wrangle with an organization here at the university about something, and I said, just tell them to show you the policy in writing. And, well, they can't. Well, of course they can't. They just made this up. You can't enforce things you make up. It has to be in writing. Laws are drawn from ethics. Now, why are ethics different than laws? Well, ethics define socially acceptable behavior, but unlike laws, it's not necessarily written down anywhere. Okay? And ethics are based on cultural mores. What is a more in this instance? The mores are a set of fixed moral attitudes or customs of a particular group. And it's going to vary greatly, depending on what group you're dealing with. The mores of certain tribes in Papua New Guinea used to allow for you to kill and eat your opponents. The laws have overruled them a little bit on that. People said, no, sorry, this may fit with your cultural mores, but we're not going to let you kill and eat people anymore. Okay? But that's the point. It varies greatly from society to society, and it is important to recognize that. Mores shape ethics, ethics shape laws. The key difference between law and ethics is what? Law carries the sanction of a governing authority, and ethics carry only societal sanctions. Okay? Only societal sanctions. They do not carry the sanction of a governing authority. Ethics are defined by some people as things that people do that are right, even when they know no one is looking. Which I always thought, that's a pretty good definition of ethics. You do the right thing even when no one is looking. Some ethics are thought to be universal. As an example, murder, theft, and assault are actions that are going to deviate from ethical and legal codes in most cultures. Lying, though, that's not necessarily true. Okay? There are certainly cultures where lying to a person in authority or lying to a family member might not be acceptable, but lying to somebody in a business transaction is perfectly fine. Even in our culture, who is allowed to lie? And if you've watched procedural police shows on television, you know this. The cops can lie to suspects, okay, in order to try to evoke a conviction. They do all the time. What's that? On TV. Okay, so let's talk about types of law. There are so many different ways to break down and categorize law. And so I'm going to throw at you a whole bunch of categories, okay? All of these have validity. They may not necessarily all be in exactly the same system of categorization. And that's kind of important to recognize. But the point is, you need to at least be familiar with the terminology and have some idea of what is meant by each of these types of law. So we have constitutional law. Constitutional law is law that originates with the U.S. Constitution, a state constitution, local constitution, or bylaws or charters. We have statutory law. Statutory law are laws that originate from a legislative branch that has been specifically tasked with the creation and publication of laws and statutes. We have regulatory or administrative law, which originates from an executive branch or an authorized regulatory agency and includes executive orders and regulations. And we have common law, case law, and precedent. These are forms of law that originate from a judicial branch or an oversight board and involve the interpretation of law based on the actions of a previous and or a higher court or board. Some law is established by judicial action. Okay, so that's sort of a one set of categories. Now we're moving on to some different categories. Criminal law are laws that address violations that are deemed harmful to society. Criminal law is actively enforced through prosecution by the state. It addresses things like traffic law, public order, property damage, and personal damage in some contexts. Okay, so that's criminal law. Civil law, on the other hand, is law that governs relations between and among private individuals. Sometimes it even governs relations between governments and private individuals, but it's civil law. This includes contract law, employment law, family law, and in some cases a branch of law called tort law, and we'll talk about what tort law is in a few moments. But the key pieces are contract law, employment law, and family law. Interestingly enough, the laws against entering the United States without proper documentation are civil laws, not criminal laws. So it's not a criminal act to enter the U.S. undocumented. It is a violation of civil law. Sometimes the term civil law is used as a very broad umbrella contextual paintbrush to describe all law outside of criminal law, which would incorporate a lot of other possible categories of law as well. Violations of civil law are most often considered to be either torts or breaches of contract rather than crimes. In other words, they are a violation of someone else. Tort law is a civil wrong other than a breach of contract for which the law provides a remedy. Okay, so the law says there is a remedy for this particular civil wrong. It allows individuals to seek recourse against others in the event of personal, physical, or financial injury. Some torts are criminal, so there are criminal torts. Assault, battery. Other torts are purely civil, like libel or slander, and some can be either criminal or civil, like trespass or negligence. So you've probably heard of criminal trespass and criminal negligence, but there's also civil trespass and civil negligence. Now, criminal torts are designated as criminal because the harm done is considered to harm society as a whole and not just the aggrieved party. But the difference between a criminal tort and other criminal law is that generally in tort law, unless the injured party brings charges, there is no crime. So if I said something really egregiously, outrageously insulting to someone in the class, and that person came up and punched me, and, somebody says, well, do you want to press charges? And I say, well, no, I shouldn't have said that. Then there is no crime, okay? One exception might be a criminal tort that is witnessed by a law enforcement officer. Because if a law enforcement officer witnesses something, they can then choose to prosecute that. I know, it's shaky, but that's generally how tort law works. So, private law is a set of law that regulates relationships between individuals, between the individual and between individuals and organizations other than government. It encompasses family law, commercial law, and labor law. So that's these areas of law. Public law regulates the structure and administration of government agencies and relationships with citizens, employees, and other governments. Public law includes several categories of law. It includes criminal, administrative, and constitutional law. Another interesting way of categorizing laws in general is that there are certain types of laws that are proscriptive law. A proscriptive law says it is unlawful to, okay? That means it's against the law to do something. Most of criminal law is proscriptive law, and criminal offenses invariably are going to be violations of some kind of proscriptive law. Then there are prescriptive laws. Prescriptive laws are different because they say you must do the following. That makes it against the law not to do something. Okay, what's an example of that? Filing your tax return. Okay, generally these are regulatory in nature, and prescriptive laws say you must do something. Okay. Now, law comes in layers when you have layers of government, depending on, and again, this varies a great deal from nation to nation. In the United States, we have federal law, we have state law, we have county law, we have city law, and even worse here in Illinois, we have township law. We can have township law. We could have park district law. We could have forest preserve law. Okay, we have so many regulatory bodies that can pass law in Illinois. It's like almost inconceivable, probably more than any other state, because we break our government down into such teeny little pieces. But basically three levels of law: federal, state, local. Okay, and local encompasses all those little pieces, parts I was just talking about. The U.S. law is structured into two types of law. We have the United States Code, okay, and you'll see it abbreviated U period, S period, C period, most commonly. These are laws that are passed by the Congress of the United States and signed by the President. Until they are incorporated into the United States Code, they are called a public law, and they have a number attached to them. Okay, so recently passed laws will not have a U.S. code number, and about every 6 years they reprint the U.S. code, and all of the public laws that have been passed since the previous printing of the U.S. code then get a U.S. code designation. So you'll see 34 U.S. code and then a section, so they get broken down that way. In many, I can't think of any cases where it's not true. Well, there may be some. But in most cases, public law, it directs the executive branch to publish additional regulations. Okay, because very few public laws are sufficiently broad to cover all cases of the law. And very often, they will then direct the executive branch to publish additional regulations. Those additional regulations are codified in what is called the Code of Federal Regulations. These are regulations that are published by executive departments and agencies as directed to implement laws in the U.S. Code. It is important to recognize that they have full force of law. There are some very strange people in the United States that believe, for whatever bizarre reason that I cannot fathom, that the Internal Revenue Service is not a legal agency, and that the laws that allow the U.S. to tax people for income tax actually only apply in the Virgin Islands. And it's like, huh? And the reason is that these people, for whatever reason, have decided that, okay, because it doesn't explicitly say certain things in the U.S. Code, that what it says in the Code of Federal Regulations is meaningless. Well, that's just not true. Okay, Code of Federal Regulations is law. Now, let's talk about relevant. Now that we have an idea of what kinds of laws there are, in most cases, things we're going to discuss in the class here are going to be either civil law or criminal law. Okay? In most cases, civil law or criminal law, pretty much straight up. The U.S. has led the development and implementation of cybersecurity legislation to prevent misuse and exploitation of information and information technology. We have more laws governing this, I think, than probably just about anywhere else. The idea here is to promote the general welfare and create a stable environment for a solid economy. Table 2-1 on pages 55 through 58 of our text summarize the U.S. federal laws that are relevant to cybersecurity. It's a 4-page summary. I thought 4 pages was too long, so I broke it down into 2 pages, stuck it in the lecture, but I also gave it to you just as a 2-page PDF you can download. So that's one. I'm not going to try to read this slide, and that's the other. Okay, so you see it's pretty small type, and there are a fair number of them. Interestingly enough, almost all of them have U.S. code numbers associated with them, unless they've been passed in, like the ones for 2014, 2015. Those have public law numbers because they haven't yet been written into the U.S. code. Okay, so let's talk about some of these laws. The Computer Fraud and Abuse Act of 1986 is the cornerstone of a lot of computer-related federal laws and enforcement efforts. It's also known as the CFA Act. It criminalizes accessing a computer without authorization or exceeding authorized access for systems that contain information of national interest as determined by the U.S. government. Okay, so it does make certain trespass upon computer systems a criminal act. It's been amended several times. It was amended in October 1996 by the National Information Infrastructure Protection Act of 1996, and it modified some sections of the Computer Fraud and Abuse Act and increased penalties for certain crimes under that act. It was further modified by the 2001 USA Patriot Act, which provides law enforcement with broader latitude to combat terrorism-related activities, making use of cyber resources. Believe it or not, USA Patriot actually stands for something. It stands for Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism. When I was in the Navy, we had lots and lots of acronyms like this, and we used to joke about the fact that the U.S. government employs some little old ladies in tennis shoes in a back room somewhere just to come up with these, and they're kind of fascinating, and they're really a stretch sometimes. The USA Patriot Act of 2001 was updated and extended, in many cases permanently, through the USA Patriot Improvement and Reauthorization Act of 2005. In May 2015, the U.S. Senate failed to extend the USA Patriot Act, so several components of that law expired on June 1st, 2015. The USA Freedom Act was signed, let me back up before I talk about the Freedom Act. In the Patriot Act, there was some controversy over what was called Section 215 of the USA Patriot Act. This allowed the National Security Agency to collect metadata, which resulted in a transfer of the responsibility for collecting and reporting this information to telecommunications companies. That wasn't permitted by the law. So what happened? They passed another law, the USA Freedom Act, that said, it's okay that they did this, even though it wasn't allowed under the previous law, just to say, okay, it's okay. And President Obama signed that into law in June 2015, basically because otherwise the telecommunications companies may have been liable. They may actually have been in violation of the law for transferring that information without authorization, but they authorized it post facto with this law. So let's talk about some laws that govern information security specifically and not cybercrime. The Computer Security Act of 1987 was one of the first attempts to protect federal computer systems by establishing minimum acceptable security practices. This act charged what was then called the National Bureau of... I'll back up here. One of the things that this law did was require mandatory periodic training in computer security awareness, and it established accepted security practices for all users of federal computer systems. The law was passed in 1987. I was an information systems security officer in the Navy, and I took my unit through the process to demonstrate compliance with the Computer Security Act in 1988. I did not know at the time, thank goodness that no one told me this. I was the first person who, in a reporting chain to Naval Air Force's Pacific Fleet, to have done that. So I was very glad I didn't know that at the time. But it was kind of interesting to look back on that. It also established a Computer Systems Security and Privacy Advisory Board within the Department of Commerce, and more importantly, it assigned the National Bureau of Standards, which is now the National Institute for Standards and Technology, and the National Security Agency to develop certain aspects of governance for cybersecurity within the federal government. They were charged with developing standards, guidelines, and associated methods and techniques for computer systems, uniform standards and guidelines for most federal computer systems, technical management, physical and administrative standards and guidelines for cost-effective security and privacy of sensitive information in federal computer systems, guidelines for operators of federal computer systems that contain sensitive information in training their employees in security awareness, and validation procedures for and evaluation of the effectiveness of standards and guidelines through research and liaison with other government and private agencies. It's a pretty big mandate, and the mandate is divided between the National Institute for Standards and Technology, NIST, and the National Security Agency, which a lot of people don't quite or may or may not be aware is actually a branch of the Department of Defense. This charge to the NSA has become a bit of an issue in the last few years because there's a certain tension between an agency that's supposed to collect information surreptitiously and an agency that's supposed to make sure information stays secure. And there's actually some likelihood that they may break off some of these responsibilities just because of that. The Federal Computer Security Act of 1987 also amended the Federal Property and Administrative Services Act of 1949, and it required NIST to distribute standards and guidelines pertaining to federal computer systems, making those standards and guidelines compulsory and binding. This is the whole series of publications of which you've already seen one, the NIST Special Publication Series and Special Publication 800 series are the series of publications specifically governing cybersecurity. The Federal Information Security Management Act of 2002, commonly known as FISMA, supersedes and updates the Computer Security Act of 1987. So a great deal of this law was really rewritten entirely in 2002 because there have been sweeping changes in how people deal with computer systems and how they use and employ computer systems in that span of years between 87 and 2002. One of the things that FISMA does is it mandates annual security audits of all federal computer systems. Now we're going to reach back to some older laws here. The Communication Act of 1934 provides penalties for the misuse of telecommunications devices, specifically telephones. It was revised in 1996 by the Telecommunications Deregulation and Competition Act of 1996, which was a serious attempt to modernize some archaic terminology in the 1934 Act. It provides broad penalties for misuse of telecommunications devices. It was targeting telephones, but it later came to have pretty serious implications for networked communications as well. It had a thing called Title V, the Communications Decency Act. The Communications Decency Act was said that some things were indecent and couldn't be transmitted under certain circumstances, but it immediately became ensnared in a legal debate over an attempt to define indecency. Now, in most American law, obscenity is something that is illegal, but indecency is not. Indecency is something that basically no one can really define exactly what it is, and consequently this portion of the law was rejected by the Supreme Court. Following the 1996 law, there was another law passed called the No Electronic Theft or NET Act of 1997. This provides for criminal prosecution of individuals who, without authorization and without realizing any financial gain or commercial advantage, electronically access copyrighted materials or encourage others to do so, which is commonly called inducement. Okay? The interesting thing about this is that in most instances, accessing copyrighted materials is a civil crime and not a criminal act. And interestingly enough, prosecutions under this act have been really rare. There were only 8 in the first 5 years, and generally they were for egregious sharing of very large numbers of files. So it's now there's a pending prosecution right now that is on extremely shaky legal footing, and we'll talk about that later in the lecture. As well as I can determine, there have been no prosecutions for encouragement or peer-to-peer file sharing, with the exception of one attempted prosecution we'll hit later. The government's been very absent in charges and prosecutions of music file sharing pursued in civil court by the Recording Industry Association of America, and movie file sharing cases pursued by the Motion Picture Association of America. These are civil cases, okay? Because violation of copyright is a civil crime and not a criminal act, except this law makes it a criminal act if you do it online. In recent years, though, it has led to seizure and shutdown of some websites by the FBI and the Department of Homeland Security. The one resulting criminal prosecution for encouragement, what's commonly called inducement, is still pending against Kim.com, who owned a file-sharing service called Mega Upload. The problem with this case, and the reason why it's in such a long ongoing legal limbo, is that the jurisdiction is very hazy, because Mega Upload is not a U.S. company and Kim.com is not a U.S. citizen. And he is a citizen of New Zealand, and they have not extradited him because the U.S. has not, to this date, been willing to provide sufficient information to persuade the courts in New Zealand that he should be extradited and tried in the United States. So, the Digital Millennium Copyright Act of 1998, the DMCA, was intended to reduce the impact of copyright, trademark, and privacy infringement, especially through the removal of technological copyright protection measures. And we're going to talk a little bit more about that later in the lecture. The USA Patriot Act of 2001, we've already mentioned. It allowed a broader range of government and law enforcement action to combat terrorist activities. One of the problems with this law, in some areas and some concern by individuals who are affected by it and organizations, is that some of the provisions and methods of this act are believed by many people to be unconstitutional, because it allows for searches and seizures that appear to be unconstitutional, and it places secret laws in the Code of Federal Regulation so that you can be tried without knowing what you're being tried for. In other words, you could violate a law and be put on trial, and you at no point are you ever told what that law is that you have violated, because the law is secret. That just doesn't, that doesn't jibe with protections that are normally accorded citizens under the U.S. Constitution. Kind of an interesting perspective. It also allowed for widespread warrantless collection of communications and digital information, some of which probably had been going on long before that anyway, but another general law that has impact on cybersecurity, it is not a cybersecurity law, but it has very broad and strong implications that require implementation of cybersecurity in many cases to comply properly with the law, is the Sarbanes-Oxley Act of 2002. It was created to address accounting irregularities, Enron being the big one, this energy company that had serious accounting irregularities to the point where their accountant, Arthur Andersen and Company, no longer exists, okay? Purely because their failure to properly audit their client, Enron. It requires internal controls and internal controls reporting, which encompass a set of general computer controls, which include some aspects of information security. The key piece is it requires something that overlaps a normal information security requirement, and that is audit trails for financial transactions. Good information security requires audit trails for all actions on a system. But this makes it very specific as to audit trails for financial transactions. And we'll talk a little bit more about Sarbanes-Oxley later in the lecture too. The Artists' Rights and Theft Prevention Act of 2005 criminalizes taping of movies in theaters. Kind of interesting. It also but this is where we run into the relationship to cybercrime. It criminalizes making unreleased works intended for public distribution, that is, beta versions or work prints. It makes it against a criminal act to make those available on a computer network accessible to members of the public. Because there was a long history of people getting work prints, for example, of motion pictures and uploading them to file sharing sites so that people could download the motion picture before it had even been released. So that made that a criminal act. There are certain laws about privacy, and privacy laws are important because many organizations online collect, trade, and sell personal information as a commodity. And individuals are becoming increasingly aware of these practices, and they are looking to governments to protect their privacy. In an interesting case that occurred, ruling that occurred this past week, one country ruled by a vote of 9-0 of their highest court that privacy is an absolute right of the citizens. What country is that? Anybody know? What? Not China. Anybody know? No? I know there's people here that are citizens of that country. India, yeah. The Indian Supreme Court ruled 9-0 that privacy is an absolute right of citizens of India. Yeah. It's a pretty significant ruling. It has very broad-reaching connotations, and is a much broader ruling than any ruling we've ever seen governing privacy in the United States. Right, they have no privacy at all. Right, yep. One of the issues that has emerged in privacy when we deal with cybersecurity and related issues is that the aggregation of data from multiple sources will allow organizations to build databases with pretty alarming quantities of personal information. Privacy in this context is not absolute freedom from observation, but it's defined typically as the state of being free from unsanctioned intrusion. If I don't go into great depth about privacy in this course, in legal and ethical issues in IT, which I'm teaching in the spring, we spend an entire week discussing privacy, and we actually read some of the seminal articles that establish privacy as a de facto constitutional guarantee in the United States, despite the fact that it's not specifically written into our Constitution. We do see some laws. There are privacy of customer information sections in the section of regulations that govern common carriers. That specifies that proprietary information should be used explicitly for providing services and not for any marketing purposes. So how do online people get away with selling your information? Because it's in their terms of service, which you never looked at, and their terms of service says, any information you give us, we can do anything we want to. So if you don't want that, don't do business with us. That's basically how most terms of service read today. Privacy in the United States is not a constitutional right, but it has been construed to be a right by the courts. Courts have held over the years in a numerous set of rulings that citizens have a reasonable expectation of privacy. And this is sort of a working definition of what this includes. A right not to be disturbed, a right to be anonymous, which used to be unfettered and unlimited in the United States, but in the past few years has become less so. Used to be, if you were not being charged with a crime, you were not required to identify yourself to law enforcement. But that's changed, and you are today. Right not to be monitored. The right not to have your identifying information exploited. Now, the problem with these construed constitutional guarantees of privacy is that they apply only to the federal government. They don't necessarily apply anywhere else. Privacy is generally construed by interpretation of the Fourth Amendment of the U.S. Constitution, which prohibits search and seizure without a warrant. And because those are constitutional guarantees, they do apply at all levels of government. So typically they percolate down to state and local government as well, because any construed rights under the Constitution cannot be overridden. Now, the federal government has a very specific privacy law, the Federal Privacy Act of 1974, which regulates how the government can make use of private information. It was created to ensure that government agencies will protect the privacy of individuals' and businesses' information and will hold them responsible if this information is released without permission. The Federal Privacy Act of 1974 does exempt some folks from regulations so they can better perform their duties. So it exempts the Bureau of the Census because the census needs to collect and aggregate data so they can ask things that otherwise the federal government would not be allowed to ask. The National Archives and Records Administration, because they are dealing with long-term records of the government, many of which existed long before there were any protections of privacy. The U.S. Congress, interestingly enough, the U.S. Congress exempts themselves from most laws. They are exempt from the Civil Rights Act of 1964, so members of Congress can discriminate in hiring based on any criteria they want to because the law doesn't apply to them. They are exempt from the Occupational Safety and Health Act. So if you fall off a ladder and you work for the Library of Congress, tough. The Library of Congress is exempt from OSHA. So they are exempt from the Federal Privacy Act. The Comptroller General of the United States, because they deal with financial information, and certain court orders and credit agencies when they have dealings with the federal government. So these are some things that were exempt from privacy. There is another privacy law, the Electronic Communications Privacy Act of 1986, that is intended to guarantee the privacy of people's communications. It is a collection of statutes that regulate the interception of wire, electronic, and oral communications. And the way it's worded, it's really hard to read because, honestly, it is so tedious because it's repetitive, It repeats this wire, electronic, and oral communications about 42 times within the body of the act. Both of these laws work in cooperation with the Fourth Amendment of the U.S. Constitution, which does prevent search and seizure without a warrant. So now we'll see a little bit of the repetitiveness of the Electronic Communications Privacy Act, or as it's commonly known, ECPA. ECPA statutes address the following: the interception and disclosure of wire, oral, and electronic communications, the manufacture, distribution, possession, and advertising of wire, oral, or electronic communication intercepting devices. This is why states are allowed to outlaw radar detectors, okay? Because this law allows them to do that. Confiscation of wire, oral, or electronic communication intercepting devices, and evidentiary use of intercepted wire or oral communications. It also addresses authorization, what steps must be taken to be authorized to intercept wire, oral, or electronic communications, and authorization for disclosure and use of intercepted wire, oral, or electronic communications, and procedure for and reports concerning the interception of wire, oral, or electronic communications, and an injunction against illegal interception. So it's a pretty broad law, and it attempts to ensure privacy in a great number of ways. So it was a lot of it was an attempt to codify rather specifically when we're dealing with these types of communication. How does the Fourth Amendment apply to these types of communication? Because the Fourth Amendment is very broad, and this was an attempt to make this very explicit. Okay. HIPAA, the Health Insurance Portability and Accountability Act of 1996, known as HIPAA, or known as the Kennedy-Kassebaum Act, it was an attempt to protect the confidentiality and security of healthcare data by establishing and enforcing standards and by standardizing electronic data interchange. It affects all healthcare organizations, anyone who deals with patient information. Okay? It requires organizations that retain healthcare information to use information security mechanisms to protect this information, as well as policies and procedures to maintain those protection mechanisms. It was the first federal mandate for people outside the federal government to be required to engage in cybersecurity practices. And it doesn't ask for anything or expect anything more than what this course is all about, which is normal practices in cybersecurity, but it makes them a matter of law if you handle identifiable patient information. It also requires a comprehensive assessment of an organization's information security systems, policies, and procedures. It also, the purpose behind all of the security is to ensure that we protect patient privacy. So the privacy standards of HIPAA severely restrict the dissemination and distribution of private health information without documented consent. I have some broad-reaching health issues, and I am a cancer survivor. I had bladder cancer. And I forget, it's been 12 years now. But every once in a while, they have to go poke me and make sure I'm still okay. So I actually, next Tuesday morning, I have surgery. Outpatient surgery, not a big deal, just some biopsies. But for my wife to know what they're going to do, I have to sign everything, to allow them to release information to her because of HIPAA. So I can tell you that people are doing this because I have to sign these things constantly to allow them to release information to my spouse. And it's pretty important that she have full information. Plus, she knows a lot more about medicine than I do. She's an occupational therapist. She's a medical professional, and clearly I'm not. So, it's but it shows how it really is effective. It provides it's known as the HIPAA privacy rule. So there are two rules under HIPAA. There is the HIPAA privacy rule and the HIPAA security rule. Okay. It provides guidelines for the use of electronic signatures based on some security standards ensuring message integrity, user authentication, and non-repudiation. Now, the one thing it was supposed to do for all of us, it hasn't done yet. Which is frustrating to me. The one thing it was supposed to do was to make your medical record and your medical record and your medical record completely transferable, because it would be in a standardized electronic form, and if you move from one doctor to another, your record is your property, you take it with you, and they can immediately start to make use of it because it is in a standardized electronic form. That's what the law dictates. That hasn't happened yet, as you probably know if you deal with multiple doctors. I had my primary care physician order a set of blood tests for me, and So I wanted to send them to the hospital where I'm having my surgery. And talk about electronic communication. I said, can I email you the PDF? Oh, no, you have to fax it to us. I'm like, what century are you guys living in? Why do I have to fax them to you? Why don't you have an email address? So, the 5 fundamental privacy principles of HIPAA are that consumer control of medical information. This is one of the big things that was intended to provide, is that it recognizes that your medical information in the past, before HIPAA, honestly, it belonged to your doctor. And if your doctor didn't want to give you your record, that was tough, But under HIPAA, it's your information. They cannot withhold any information from you. It places boundaries on the use of medical information. It provides for accountability for the privacy of private information. What do we mean by accountability? It's a crime to reveal private information. And people have been charged with this. One of the things that you might imagine does happen sometimes is because there's such a cult of celebrity in many places in the world, certainly in the United States. I mean, we have People magazine, we have Us magazine, we have We magazine. People just want to know about people who are not famous for anything other than being famous. The one people trot out all the time is Kim Kardashian. What's she famous for? For being famous. But and maybe a tape. I don't know. People will reveal health information about celebrities, and that used to be not uncommon. But today, if you do that, you can be charged with violation of HIPAA, and it's a pretty serious charge. Okay. HIPAA is intended to balance public responsibility for the use of medical information for the greater good against the impact to the individual. Because there are certain things that have to be shared. Okay, if you have an endemic disease, it has to be tracked. Okay, if you have a communicable disease that's easily communicable, they have to track communication of that disease. They have to balance these things. And finally, security of health information. They passed a couple additional amending acts to HIPAA, 2 laws, ERA and HITECH, the American Recovery and Reinvestment Act, which interestingly enough was designed to provide a response to the economic crisis in the U.S., but it included another internal act called HITECH, the Health Information Technology for Economic and Clinical Health. Another one of those, boy, that's a real stretch to come up with HITECH, which was, ERA was focused on providing tax cuts and funding for programs, federal contracts, grants, and loans, but it tied into health information technology. And one of the things that came out of HITECH was a requirement that covered entities, that is, people that fall under HIPAA, must notify information owners if there's a breach of their data. Okay? So if there's a breach of your healthcare information, by law, the custodian of your healthcare information is required to inform you of that. Okay? The Gramm-Leach-Bliley Act, also known as the Financial Services Modernization Act of 1999, is a law that applies to banks, securities firms, and insurance companies. Essentially, the entire financial services, what we think of as when we discuss financial services firms. It requires all financial institutions to disclose privacy policies, describe how they share non-public personal information, and describe how customers can request that their information not be shared with third parties. It ensures that privacy policies are fully disclosed when a customer initiates a business relationship, and ensures that privacy policies are distributed at least annually for the duration of the professional association. Why is it included here? Because privacy today typically means privacy not just of information written down, but digital, because everything's digital. Money is digital. most money today in the world, there's not the level of currency in gold floating around there once was. Most of the money in the world today is ones and zeros somewhere. Some other interesting laws. Export and espionage laws. The Economic Espionage Act of 1996. You can see that in 1996 and 1997, Congress got real busy with these laws because they passed a whole bunch of laws right in that time frame. This attempted to protect intellectual property and competitive advantage. It tries to protect trade secrets from, quote, the foreign government that uses its classic espionage apparatus to spy on a company, to the two American companies that are attempting to uncover each other's bid proposals, or to the disgruntled former employee who walks out of his former company with a computer diskette full of engineering schematics. So there's a lot of different things that fall under this particular law. One of the most important things to note, though, under the Economic Espionage Act is that if you retain proprietary information from a former employer when you depart their employment, you may actually be in violation of the Economic Espionage Act of 1996. The Security and Freedom Through Encryption Act of 1997 provides guidance on the use of encryption, and it institutes measures of public protection from government intervention. We hear many people in the federal government arguing for a backdoor in encryption. And a backdoor in encryption, which anyone who deals with this at a professional level recognizes that a backdoor for anyone is a backdoor for everyone. Okay, but this right now they can't require that because this law says you can't. Okay, it reinforces the individual's right to use or sell encryption algorithms without any concern for the impact of other regulations requiring some form of key registration, which was the early attempts to create backdoors into encryption. Third-party key registration so they could get your key and read your encrypted material. Well, this law made that, not the case. It prohibits the federal government from requiring the use of encryption for contracts, grants, and other official documents and correspondence, which is kind of odd because it means that things by this law can't be digitally signed. But they've chosen to not interpret it that way. Despite the letter of the law, they've chosen to go with the spirit of the law. The Freedom of Information Act of 1966 provides any person the right to request access to federal agency records or information that are not determined to be in the interest of national security. The U.S. government agencies are required to disclose requested information on receipt of a written request. However, the only recourse for failure to produce documents is a lawsuit, which is expensive. So, if the government doesn't want to give it to you, then you have to bring a lawsuit against them. There are some exceptions for information that is protected from disclosure. It doesn't apply to Congress or the federal courts. It doesn't apply to state or local government agencies, and it does not apply to private businesses or individuals. It's just a federal law, and it doesn't apply to courts or Congress. Many states, however, have their own version of the Freedom of Information Act. In 2000, the United Kingdom passed their Freedom of Information Act, which is very similar in all respects to the U.S. law, but it has more exceptions. Let's loop back for a minute and talk in a little bit more depth about some of these laws that we kind of passed over here. The Sarbanes-Oxley Act of 2002, because it is intended to enforce accountability for financial record keeping and reporting at publicly traded corporations, it directly and specifically charges and requires the chief executive officer and the chief financial officer to assume direct and personal accountability for the completeness and accuracy of the publicly traded organization's financial reporting and record-keeping system. Okay? Now, one of the things that you would hear when people would talk about financial irregularities at companies is they would talk about companies that keep two sets of books. Okay, because in the old days, my dad owned a business back in the 1960s and 70s, and all the records were in ledgers. Okay, and so if people were doing something weird with the money within the company to hide money from taxes, for example, or to hide money that was coming from illegal sources, they would have two sets of ledgers, one with the real money, because honestly, you have to do that or you can't keep it straight. Even if you're engaging in criminal activities, you better keep good track of the money or you'll mess everything up. And then the doctored set of ledgers, so people talk about this two set of books. Well, what happens today? All the records are digital, right? So if somebody were trying to keep two sets of books today, they would have to be digital. And ideally then you would hide something because you don't want auditors to see the records that you still have to keep, so you keep everything straight. This is why an example of this is, I believe he's been promoted out of this, but there was an IIT alum who got involved in cybersecurity, and he was, I hate to admit this, he was a CS major, but, you know, he's actually been very closely involved with ITM because he was working, providing some security for some of our systems when we first started the degree. Anyway, he works for a major accounting firm, and for several years, his job was he was the digital forensic investigator for a financial accounting audit team. Okay? Because it was his job to dig out anything they've hidden on the computer systems. I mean, that was part of his job, was to look for stuff that's hidden on the computer systems. Because, you know, it used to be, what would you do in the old days when you had two sets of books? Well, you'd carry one off premise when you had an audit, so no, it wasn't there for anybody to look at. But today, it's digital. So, in an attempt to ensure that this is not possible, we have the Sarbanes-Oxley Act, which requires, you know, direct audit trails for every financial transaction that's recorded in a publicly traded corporation. As these executives attempt to ensure that the systems that are used to record and report are sound, often they rely on the expertise of the Chief Information Officer and the Chief Information Security Officer to do so. The related areas of availability and confidentiality are also emphasized, because what they're requiring by this law still is part of information security, right? Integrity. But they're requiring, you know, documentable integrity of the records. So let's talk a little bit about, talk a little bit about some civil law. Copyright law. Copyright, what is copyright? Well, copyright is a set of exclusive legal rights that authors have over their works for a limited period of time. Okay? These rights include the right to copy the work, including parts of the work, the right to make derivative works, the right to distribute the works, and the right to perform the works, including showing a movie or playing an audio recording, as well as performing a dramatic work. Copyright in today's law exists upon creation. In previous iterations of copyright, items had to be registered to be copyrighted. But in today's law, copyright exists upon creation. So an artist's rights begin when an original work of authorship is fixed in a tangible medium. This includes words published in electronic formats, or images in electronic formats, or music in electronic formats. Okay? That is considered, for purposes of copyright, to be a tangible medium. A work does not have to bear a copyright notice, nor does it have to be registered to be copyrighted. It is difficult, okay, not impossible, but it is difficult to prosecute someone under civil law for violation of copyright if you've not registered the copyright. Okay, it gives you much, much greater standing before the courts. intellectual property is recognized as a protected asset in the United States, and U.S. copyright law extends this right to all of the published word, including electronic formats. It is granted for, and this is words from the U.S. Constitution, for limited times to promote the progress of science and useful arts. One of the things that is interesting about copyright law in the United States is it does include a provision called fair use. Fair use, contrary to what a lot of people who are in the intellectual property industries would tell you, is not an exception to copyright law. It is an integral part of copyright law. This fair use of copyrighted material includes the use of copyrighted material to support news reporting, teaching, scholarship, and a number of related permissions. The purpose of the use, for it to be fair use, has to be for educational or library purposes. It can be for, there's some interesting exceptions. It can be for purposes of parody. Okay, that's an allowable use, fair use. And it cannot be for profit, and it should not be excessive. And the not-for-profit, that's really not even true. There are certain things that can be done under fair use, even for profit. One of the things that's interesting about copyright law in the United States is copyright law is one of those things that in some senses in the U.S. is determined by the courts. Okay? So if I'm publishing a magazine, let's just say Mad Magazine, and I want to parody the latest Mickey Mouse cartoon, and I publish my magazine in New York, I can do that. And if Disney brings a case against me based on the body of case law in that federal circuit court, they will lose. But if I publish a humor magazine in Los Angeles, and I want to parody the latest Mickey Mouse cartoon, and Walt Disney Corporation takes me to court, I will lose. And I will lose every time. And I can't say that it's the case for all parody, but Disney has never lost in that circuit, and they've never won in the circuit that includes New York. And I just picked New York and Los Angeles because that's, centers of the publishing industry in the U.S. I don't know about...
Because Disney, without people noticing, tends to just slide over a stack of money to...
Well, I'm not going to say anything about that. But,
not telling you about it.
But I don't think they're paying off judges, but it's established precedent in those circuits. And the U.S. Supreme Court has never become involved in any case concerning Disney. So... one of the parts of the U.S. copyright law is the Digital Millennium Copyright Act. We'll talk more about that in a moment. What is fair use? Well, fair use allows for limited copying or distribution of public works without the author's permission. Examples are quotation of excerpts in a review or critique, or copying of a small part of a work by a teacher or student to illustrate a lesson. Determination of fair use is based on this four-factor test. Purpose and nature of the use, nature of the copyrighted work, nature and substantiality of the material used, and effect or use on the potential market for or the value of the work. Some things that on the surface would not look like they would be fair use, in fact, have been ruled to be fair use. An example of that is Google Books. Google at one time, before they got enmeshed in court cases about this, they were going to scan every book in the English language, which is, an admirable quest. And they scan a very large number of books. And one of the things that they have done is if you do a Google search and your search reveals something that's in a book that they have scanned, it will take you to the page of that book. Okay? Now, in many cases, those books are copyrighted. And in order for that to work properly, they had to scan the entire book. Well, some folks took Google to court and said that violates the author's rights because nature and substantiality, you've scanned the entire work. And Google's argument is, yes, but we are not making the entire work available, and we cannot provide this service without having scanned the entire work. And then Google's turnaround argument coming back is the effect or use of, on the potential market for the value of the work is uniformly positive, because if somebody's looking for something in particular and they find it in the book and they need that book, they'll go buy the book. So it's interesting because the courts actually ruled that it is still fair use for Google to have scanned entire books. So fair use is really interesting. And I do mention again, it's not an exception to copyright law. It is an integral feature. Proper acknowledgement has to be provided to the author or copyright holder of such works, including a description of the location of source materials by using some recognized form of citation. Fair use is specific to U.S. copyright law, and that's kind of important to remember because that may not hold true anywhere else in the world. U.S. and Canada have a term very similar called fair dealing, which is very similar to fair use, but it's considerably narrower in scope. And Australia has neither fair use nor fair dealing. So, it varies greatly from nation to nation. One of the things that's important to recognize is that if fair use does not apply and you want to make use of someone else's intellectual property, you must have a license from that person. A license is not a given. The owner of intellectual property does not have to grant a license, nor do they have to provide any explanation when they don't. They can just say no. One of the things that's important to recognize is a lot of people for a long time thought, well, if people put stuff on the web, I can use it. Well, no, putting stuff on the web doesn't put something in the public domain unless you specifically make that assignment in form of licensing. And under U.S. law, you cannot legally place something into the public domain. We do have a form of licensing that allows you to do the equivalent through Creative Commons. It's called a CC0 license, which is, for all practical purposes, placing something in the public domain, but you're doing it by licensing it. Some websites that contain content material of all kinds where material is either in the public domain or license for use is clearly granted, but otherwise, any work that you find online, video, audio, graphic arts, text, they're protected by copyright, and reuse of that material requires a license. The Digital Millennium Copyright Act is the U.S. version of a concerted international effort to reduce the impact of copyright, trademark, and privacy infringement. Many legal experts feel that the Digital Millennium Copyright Act illegally infringes on fair use and has other adverse effects. Why does it infringe on fair use? Because under normal circumstances, when you could make fair use of some resource that you have available to you, if it is protected by technical means and you have to circumvent that technical means to make fair use of it, you are then violating the law. Okay? Some of the critics of the Digital Millennium Copyright Act claim that it has had the following impacts, among others. It's being used to silence researchers, computer scientists, and critics. And that is true. And there have been people there was a Russian researcher who came to a conference in Arizona, and he had published a weakness that he had discovered in a protection mechanism that people were using. It was a security vulnerability, which is why he published it. And he got arrested because in order to discover this vulnerability, he had to breach the technical protection mechanism. So that's a problem. The corporations are using it against the public, and public college radio stations, I think this has been resolved but when it first came out, they couldn't afford a webcast. You couldn't simultaneously webcast with your broadcast because you'd have to, in some cases, violate the DMCA. It's also had this, as I just discussed, this stifling effect on computer security research because it prohibits the circumvention of copy protection and the distribution of devices that can be used to circumvent copyrights. In doing so, it treats publishing of security vulnerabilities as a violation of the law, which should, not be the case. has anybody ever heard of the one aspect of violation of the DMCA that could be done by 12-year-olds? 12-year-olds who had no technical knowledge at all? For a while, the recording industry in the United States tried to prevent ripping of tracks of CDs. Okay, so they put an anti-circumvention code on CDs. So when you put this CD in your computer could not rip tracks. So the way you would get around this anti-circumvention code is you would take a Sharpie and draw a black circle around the inner track of the CD, and that covered the anti-circumvention software, which then allowed you to rip the tracks off the CD. But it made you a federal criminal.
One black circle makes you a criminal.
Yes, that one black circle made you a criminal.
You could go to jail for drawing.
You could. Okay. There have been some laws that have been tried to pass. The Congress has tried to pass. The Stop Online Privacy Act was similar to the Digital Millennium Copyright Act, but far more draconian. It would allow takedowns of entire sites based on accusations with no court action. Historically, this is something that's been unconstitutional under the First Amendment. That's something called prior restraint. It included felony penalties for non-commercial streaming infringement of copyrighted material, and it could have resulted in criminal prosecution of public libraries, probably would have resulted in the complete shutdown of YouTube and possibly even many search engines. So it was defeated because the tech industry rallied to say, hey, no, this is a little too much. One of the things that we have seen over the years is bills that are designed to protect consumers by requiring reasonable security policies and procedures to protect your personal information. The Data Security Act of 2010, the Data Security and Breach Notification Act of 2010, the Cybersecurity Act of 2012, all of these failed to pass. Probably similar legislation may make its way through Congress, but Congress actually just voted to let anybody share your information with anybody they want to. So, international laws and legal bodies. Many domestic laws and customs don't apply to international trade, which is governed by international treaties and trade agreements. We're going to take a break in just a few minutes here. Because of cultural differences, the political complexities of the relationships between nations, there are very few international laws that relate to privacy and information security. There are breach laws that specifically specify a requirement for organizations to notify affected parties when they've experienced a specified type of loss in information. I'm sorry, that one slide is out of order. I apologize. That should have come later. Most breach laws also require some form of after-breach support from the organization, like free or discounted credit monitoring, progress reports, and a description of actions that have been taken to rectify the incident and prevent reoccurrence. The problem is that in the United States, we do not have a national breach law, but several bills and proposals are being reviewed by Congress. 10 U.S. states have data breach laws that require that you be notified if your data has been breached. 14 states and the District of Columbia, Puerto Rico, and the Virgin Islands allow you to place a lawsuit to redress a data breach. Okay, so it's kind of interesting. It makes it hard not having a national data breach law because it varies from jurisdiction to jurisdiction. And one of the things that we've seen companies do who have had major data breaches would be to notify all their customers in the 10 states where they're required to do so by law and not notify anybody else. Okay? Because they're not required to. So they just don't. customers who find out about that in other states get kind of unhappy and fussy at those companies. So, let's take a 10-minute break. It is 7:45. We will come back at 7:55, and we will continue. Okay.
I was hoping you could give me some advice on this topic
Okay.
for my assignment. Sure. I wanted to do a manual of sorts to prevent corporate espionage. I'm wondering, and you mentioned specifically in the syllabus, to be specific, so I'm wondering if that would be too broad, or if you'd recommend going towards preventing corporate espionage for, say, pharmaceutical companies, or preventing corporate espionage for financial management companies.
Well, when we talk about breadth and things being too broad, I think it's not so much the sector that would be important as the area of espionage that you're going to cover. So the area of espionage that you need to specifically address is through digital means.
I would assume that would be.
Okay. Well, that's not going to be that. The sector there doesn't make a difference. It doesn't matter, But the presumption is you're going to talk about, hey, and what you're really talking about is a set of policies, and it depends on how specific you want to get. You can do policies, you can do standards, you can do procedures, even to ensure that there's proper protection against espionage. But that's a valid topic.
Okay.
But you need to, very, very specifically focus on digital mechanisms, because there are a lot of other ways people can engage in espionage, but you need to
I assume the scope of this course just covers electronic
Right,
records
right.
and whatnot. Doesn't.
Right.
I don't even know at the top of my head what else. That could
Paper records, theft of briefcases,
Oh, okay. So you're saying
Okay.
that would not be following the rules of the assignment to include any physical.
Right, because that's outside the scope of what falls within the concern of the course.
Even though physical controls are often.
Yeah, well, but when you talk about physical controls, in this instance, we'd be very specifically addressing physical controls for digital devices, So, for example, the fact that people can't leave a notebook computer unattended or things like that.
Okay, so you don't. So in short, you don't believe that just having being indiscriminate towards what industry, that's not too broad.
No.
Okay.
No. Because to be perfectly honest, combating industrial espionage really is not sector specific. I mean, yeah, okay. There are some industries where there would be some aspects of the industry that are distinctive.
Yeah.
Right. And if you wanted to do pharmaceuticals as an example, certainly you could do that. I wouldn't have an issue with that. Because clearly the pharmaceutical industry has a little bit different kind of infrastructure than some other companies.
I thought it through. I did read one particular research paper which talked about pharmaceutical companies encrypting their recipes, for lack of a better word,
Right.
using color coding schemes,
Yeah.
but that would go beyond the scope of this because that's not electronic. They basically try to hide what the ingredients are actually in something when it's in a trial phase.
Yeah, if it's in print, then it's not. It's digital. So, yeah.
Okay.
Yeah.
All right. Thank you. Sir.
Okay. Sure.
It's a very listen your email to you. Going to the class that I wanted to register. IIT India 411.
Okay.
To give me permission to register for I'm not able to give me an error message that I include on the email as well.
Okay.
And what was the last thing? Sunday.
Yeah. be able to look. Here. Yeah, I may have to address that. If, maybe it's gonna work. No, it doesn't work. Yeah, I can't get to it now. Yeah, it won't run on. I can't. The application I need to run from within my IIT won't run on Windows 10, near as I can determine. So, but were you registering for the online section?
Yes.
Yeah. If it won't, if you can you see that you have a permit for the section? Okay, but you, I mean, you can in my IIT. Can you see the permit?
I don't know what to take a look to see.
Yeah, in academics and the academics tab, you should be able to see your permits. Yeah, there's a list there, and
The problem is when I'm trying to do it, it says it's closed. The section says the section is closed.
well, that's probably true.
Yeah, because I'm able to do anything in there.
Yeah, well, closed means it's full,
It's full.
and I can't permit past full. Now, have you attempted to register? Or are you waitlisted?
When I try to register for it, it says you want to be in a great place. I said yes.
Okay, so you are waitlisted.
Yes.
Okay. You can reasonably expect that we'll try to clear the wait list.
Okay.
Because we make every attempt to clear the wait list for every undergraduate class. Let me look at it right now and see. So this is 411,
Yes.
the live or the online section?
The honest.
Online section. Okay. For 1102. You sure? I show no one on the wait list there.
Just added 2 hours before the class today.
This is
I can make sure I can.
This is supposed to be a real-time report that I'm looking at, and it doesn't show anybody on the wait list. So, yeah, I'm reasonably certain that if you went on the wait list, we would get you in there. So,
Sure.
so make sure you're on the
right
wait
now.
list, okay?
Sure.
Yeah, and that should get you in there
Thank you, sir.
as long as you have the permit to register. So. Okay.
I just want to let you know, I have an iPhone for this, and we tend to go over. It's a socialized though, talking about everything, assigning assignments, so that's why I was giving this away today.
Okay.
It's an IIT tower, so
Tell your iPro mates that you can't go over
the a lot of times.
because it's not you per se, but there was a whole slew of people came in well after you tonight. And so what my recourse when I see that happening constantly is to give quizzes.
Oh, that's
So,
right. Yeah.
So,
Okay.
you tell them, hey, I got to go on time or I might lose points in the class.
Okay.
And like I say, I'm not picking on you. That's it, I'm picking on the people that show up 10 minutes in. Yeah. Yeah. Okay, let's get started again, please. If I could have some quiet here. Let's talk about some non-legislative regulatory acts that influence our industry significantly. One of these is the Payment Card Industry Data Security Standard. Okay, so it's important to recognize that there are regulations that are not government regulations that are going to influence cybersecurity professionals and in many cases dictate how it is that they have to do their job. This is a huge one here. This is a set of industry standards that are mandated for any organization that handles credit, debit, and specialty payment cards in an effort to reduce credit card fraud. It is driven by a group called the Payment Card Industry Consortium, which is not surprisingly, consists of Visa, MasterCard, Discover, and American Express. So, and they have this pretty binding set of cybersecurity standards that if you process credit card information, you must comply with. The current standard, 3.1, focuses on 12 requirements in 6 areas. And later on, when we talk about some models and standards, we'll go into a little more detail in a discussion of the PCI DSS. But the benefits of complying with PCI DSS are that it creates an assertion that systems that are processing payment cards are secure in order to promote trust in customers. It improves reputation with the payment card issue and payment processing organizations if you're compliant. It prevents security breaches. It assists in complying with other security standards like HIPAA and Sarbanes-Oxley and Graham-Leach-Bliley. Okay, so all of those ones that we've discussed, odds are if you're PCI DSS compliant, you're probably also compliant with those other federal standards. It provides strong support for organizational security strategies, and it provides for increased efficiency of the information infrastructure. Now I have my misplaced slide earlier, and I again apologize. And here I have exactly the same slide. So I did have it in the right place. I just had one in the wrong place. Like I said earlier, many domestic laws and customs don't apply to international trade, governed by international treaties and trade agreements, and there are very few international laws relating to privacy and information security. Some of them that do exist include the European Council Cybercrime Convention, which empowers an international task force to oversee a range of internet security functions, and to standardize some technology law, to attempt to standardize some technology laws internationally. It attempts to improve the effectiveness of international investigations into breaches of technology law. There are some countries where, quite frankly, there are not things that are against the law here that are not against the law there, and even if they were, apparently they've the term you hear in the former Soviet republics is the public prosecutor. That's what they call it, the person they've paid off, the public prosecutor. So if you want to set up a fake antivirus operation out of Riga in Latvia, you can register everything under your own real names because nobody's going to be able to come after you for selling fake antivirus software, for hijacking people's computer and saying, "Oh, you have a virus, you need to buy this antivirus software." And because back when that was a real big deal, I investigated several of these companies and found that they were pretty much operating in the open in Lithuania or Latvia, and nobody there cared. So. The overall goal of the European Council Cybercrime Convention was to simplify acquisition of information for law enforcement agents in certain types of international crimes, as well as improving the ease of extradition for violation of the law in other countries. There is some strong privacy protections under some international conventions. The European Union Directive 9546 EC increased protection of individuals in the processing of personal data and really seriously limited the free movement of that data to provide strong consumer protections. And it would only allow firms operating within the European Union to gather information necessary for a transaction and disallowed the opportunities to transfer personal data to another company without the permission of the person from whom the data was collected. And that permission is probably in their terms of service, which you didn't read anyway, so they just go ahead and do it. But it's tougher in the European Union, and they do attempt to enforce this. The United Kingdom at that point hadn't necessarily signed on to all European Union directives. Now they're Brexiting. So they have some of their own rules. They have something called the database right that is very similar and is intended to protect privacy. Australia has a the High Tech Crime Act. They have their computer offenses of the Criminal Code Act in 1995 specifically outlaws data system intrusion such as hacking, unauthorized destruction or modification of data, and actions intended to deny service of computer systems to the intended users like denial of service attacks. It also made it illegal to create and distribute malicious software like malware, okay, viruses and worms and things like that. So that's a little bit, few of the international laws. State and local regulations. It is important to recognize in the United States that each state or locality may have laws and regulations that impact the use of computer technology as well. Information security professionals have a responsibility to understand state laws and regulations and ensure that the organization's security policies and procedures comply. Let's look at Illinois law. Operating internet gambling in the state of Illinois is criminal. Anyone who knowingly establishes, maintains, or operates an internet site that permits a person to play a game of chance or skill for money or other thing of value is in violation of this law. And one of the things, what did I say about laws? If you can't provide a citation, it's not really what the law says. So when I cite the law, generally I try to provide a citation. The interesting thing about this law is that the wording of this law would seem to make some fantasy football sites illegal under Illinois state law. I don't think the state of Illinois is going after anybody for fantasy football, but by the letter of the law, it's not legal in this state. Okay. The Illinois Computer Crime Prevention Law makes unauthorized computer use a criminal offense. And that's from 720 Illinois compiled statutes, and like I say, there are 3 offense categories defined under the Illinois Computer Crime Prevention Law. Computer tampering, where access is gained to a computer, a program, or data without permission from the owner. Unauthorized access is just a misdemeanor, but it is a criminal act. Obtaining data or services is a misdemeanor for the first offense, but a felony for subsequent offenses. Altering, damaging, destroying, or removing a computer, a program, or data is always a felony. So if you steal someone's computer in Illinois, and it would be misdemeanor theft under the law that governs theft, it's a felony because it's a computer under this law. The latter 2 offenses, the obtaining data or altering, damaging, destroying, include use or attempted use of a computer virus. It's specifically cited in the law there. Aggravated computer tampering is when computer tampering has the intended effect of disruption or interference with vital services or operations of state or local government or a public utility, or creates a strong probability of death or great bodily harm to other individuals. That's a felony. And finally, computer fraud, when access to or use of a computer, program, or data is gained as part of a scheme to deceive or fraud. That includes the use of a computer to gain control over money, services, or property. In addition to its normal meaning, property in this context, under the computer fraud portion of the statute, includes electronic impulses, electronically produced data, confidential or copyrighted material, billing information, and software in any form, and that is punishable as a felony. So, defamation, libel, and slander. Generally, libel and slander are civil injuries with enforcement by lawsuit. Slander is malicious, false, and defamatory spoken statements. Okay? It's important to recognize that they have to be all 3, okay, in order to be classified as slander or libel. It has to be malicious. In other words, it has to be done with malicious intent. That's a really hard thing to prove in court. It has to be false. That's relatively easy to prove. It has to be defamatory. It has to, defame someone. And so libel are malicious, false, and defamatory statements made through any other form of communication other than the spoken word. Written words, images, anything like that. one of the things that we see is that there's been a move to treat statements that are offensive but are either true or are opinion as defamation. Why do we see that? Because to be perfectly honest, a lot of lawyers don't know the law very well. And there are plenty of lawyers out there willing to bring defamation. They're willing to bring slander or libel suits where the level of defamation fails to rise to the actual definition of slander or libel. But in some cases, people will settle because it's expensive to fight against someone who's well-funded, okay, which is really interesting. But, yeah, there's a lot of people out there. It's really frustrating to me. Like I say, I am not a lawyer, but I know there are a lot of lawyers out there that aren't very good lawyers either because they just bring cases where people have expressed an opinion and they say, oh, that's slander. No, an opinion can't be slander, so. Let's talk about the difference between policy and law. Policy is internal rules for businesses and for organizations. Policies may carry internally the force of law, but they are not law. They are a statement of intent that are normally further implemented then as a procedure or a protocol. Policies act as laws for the enterprise, and information security in organizations is established by policies, and of course that's a key focus as we move through the course. You're going to hear us talk about policies throughout the entire course because that's a lot of how we manage security within an enterprise. The key difference between policy and law is that ignorance of policy is a fully acceptable defense. If you don't know about a policy, then you can't be held to the policy. There is an interesting exception to that. Do you guys know all the policies in the student handbook? Guess what? You're still responsible for them. Okay? Because in academia, it's been clearly held that by attending class, you are agreeing to, you don't have to explicitly agree that you're going to abide by the policies of the institution. It's implicit. And it does make academic policies enforceable even when you are ignorant of the policies. Sorry about that. But in other organizations, that's not the case. Ignorance is an acceptable defense. So policies, in order to be functional, have to be distributed to all the individuals within an organization who are expected to comply with the policies. They have to be easily and readily available for employee reference. They have to be easily understood with multilingual, visually impaired, and low literacy translations. And they have to be acknowledged by employees with a consent form. And finally, they have to be uniformly enforced for all employees. Lack of uniform enforcement of policies makes them unenforceable. Okay? Let's move on from law and policy and talk about ethics. Talk about some ethical concepts in cybersecurity. Cybersecurity students are not expected to study the topics of ethics in a vacuum, but rather within a larger ethical framework. Some people define ethics as the organized studies of how humans ought to act. Others define it as a set of rules that we should live by. But the fact is that people that are employed in the area of cybersecurity may be expected to be more articulate about the topic of ethics than other people within the organization. And often they must be expected to withstand a higher standard of scrutiny as to their compliance with ethics. Now, there are some foundations and frameworks of ethics, and this is the mile-high look, okay? In our legal and ethical issues class, we get into great detail about each of these, but these are some types of ethics and that form the foundation for ethics. We have normative ethics, and normative ethics is a study of what makes actions right or wrong. We have metaethics, which is a study of the meaning of ethical judgments and properties. We have descriptive ethics, which is a study of the choices that have been made by individuals in the past. Normative ethics assumes that there is right or wrong. Descriptive ethics looks at what people have done in the past, and from that tries to determine what's right and wrong. We have applied ethics, which applies moral codes to actions that are drawn from realistic situations. And we have deontological ethics, which is a study of the rightness or wrongness of intentions and motives. Okay? From the ethical frameworks that we've just discussed, we derive a series of ethical standards. We have the utilitarian approach, which emphasizes that an ethical action is one that results in the most good or the least harm. This approach strives to link consequences to choices. We have a rights approach, which suggests that the ethical action is the one that best protects and respects the moral rights of those who are affected by that action. It begins with a belief that humans have this innate dignity based on their ability to make choices. And then we have the fairness or justice approach. The fairness or justice approach is founded on the work of Aristotle and other Greek philosophers who contributed to the idea that all persons who are equal should be treated equally. So it defines ethical actions as those actions that have outcomes that regard all human beings equally. So they are each different approaches. They each have validity in their own contexts. Arguably, some of them can be misused. For example, the utilitarian approach might say that, oh, look, I've just become the chancellor of Germany, and our country is in terrible shape, and it's there specifically because of all these Jews. So it will be the most good for the German people if we eliminate all of the Jews in our society, and that's what Adolf Hitler tried to do. But it was defensible under the utilitarian approach to ethics, so that people could defend it and say this is an ethical action, even though clearly it probably was not. I certainly would not view it as one in any context. So let's talk about ethics in information security. From the ethical frameworks, we derive a series of ethical standards. The most common ones that we see are the common good approach, which is an approach that tends to focus on the common welfare, and a virtue approach, where we see that people believe that ethical actions ought to be consistent with some so-called ideal virtues. These ethical standards or approaches will offer a set of tools for decision making, and it extends into the era of computer technology. I had mentioned previously that there is much more coverage of all of this in ITMM 485, ITMM 585. It's an entire course that addresses big chunks of these issues as in the course. There are some ethical concepts in cybersecurity, and we're going to talk about some of these. One of the simple ones that gets tossed out there and is very common and is worded what to some people's ears might sound oddly because it's written to sound like the Judeo-Christian Ten Commandments as they come from the King James Version of the Bible. We have the Ten Commandments of Computer Ethics from the Computer Ethics Institute. And so they use the King James language, thou shalt not, Thou shalt not use a computer to harm other people. Thou shalt not interfere with other people's computer work. Thou shalt not snoop around in other people's computer files. Thou shalt not, and then snoop around. That makes my brain sort of explode. It's just not. Thou shalt not use a computer to steal. Thou shalt not use a computer to bear false witness, which in the Judeo-Christian Ten Commandments is how they say lie. Okay. Thou shalt not copy or use proprietary software for which you have not paid. Thou shalt not use other people's computer resources without authorization or proper compensation. Thou shalt not appropriate other people's intellectual output. Thou shalt think about the social consequences of the program you are writing or the system you are designing, and thou shalt always use a computer in ways that ensure consideration and respect for your fellow humans. One of the things that we see when we start dealing with cultural influences on ethical concepts is that there are differences. There are differences in cultures that cause problems sometimes in determining what is ethical and what is not ethical. Studies of ethical sensitivity to computer use reveal different nationalities have different perspectives. Difficulties arise when one nationality's ethical behavior doesn't correspond to that of another national group. One of my pieces of prior education was when I was a flight instructor in the Navy. I was, for the Navy's Advanced Helicopter Training Squadron, I was in a role that was effectively the dean. I was the student control officer, and I functioned as both dean of students and the academic dean. I monitored people's academic progress and their day-to-day student problems, you know. And I was also the foreign training officer, and I had I had the first group of Saudi naval aviators come through. And one of the things that they discussed with us is why some ethical formations are different in some societies. And I never thought about this, but they pointed out to us that if you're a Bedouin and you're in the desert, you know, the desert wastelands of Arabia, you absolutely have to rely on your fellow tribesmen. And everything is done cooperatively, because if you don't, you know, as an individual, you're probably going to die out there in the desert. And that you have to cooperatively work on everything. And that results in an ethical system that views what is not acceptable cooperation in Western society, especially American society, where there's a great deal of emphasis placed on the value of individuality. And it's not because it's wrong, it's just because it's different. It's because it forms some cultural ideas about what is ethical that specifically relates to the circumstances in which people were living. And those carry forward. And I was like, wow, that's amazing. I never stopped to think about, you know, some of the reasons why we see some very different cultural formations as to what constitutes ethical behavior. So, you know, in those societies, collaborating on an exam would not be viewed as unethical at all, because collaboration is the norm within the society. That being said, the first Saudi naval aviators we had, these guys were amazing. They were awesome. They were great guys. The one guy, I pinned the wings on one of them, and he actually, I still don't quite understand how this works. He became a general in the Saudi Navy. I don't understand how you're a general in the Navy, because they also had admirals in the Saudi Navy, so I didn't quite understand why he was a general in the Saudi Navy. But differences in computer use ethics are not exclusively cultural either. Some of it has to do with education. Differences are found among individuals within the same country, the same social class, and even the same company. Key studies reveal that the overriding factor in leveling ethical perceptions within a small population is education. So education as to what constitutes what most folks would perceive as the ethical norm for how you behave in a computer-based organization. So employees have to be trained in topics related to information security, including the expected behaviors of an ethical employee. It's particularly important in areas of information security. Many employees may not have had the formal technical training to allow them to understand what behavior is unethical or illegal. So proper ethical and legal training is vital to creating an informed, well-prepared, and low-risk system user. The impact of that unethical behavior is interesting, because how did ethics used to be enforced in most of society? Well, the girl here going, I can't believe you would behave so unethically. I'm so ashamed. Because in large part, ethics were governed by personal or family shame. You know, And that's not a particularly popular concept these days. And face it, you know people, just like I do, that have no shame. It's just not a concept that even occurs to them. But there are some things that still do need to be considered, and one of those would be, professional disgrace, because as a member of a profession, and we don't get into detail about the profession issue here, again, we spend a big chunk in legal and ethical issues talking about what constitutes a profession. But professional disgrace is not behaving in accordance with the standards, the normal and accepted standards of the profession, and liability for the employer. Okay, either ethical then there are different kinds of liability. There's legal liability. That's a bad thing. That's breaking the law. But there are also ethical liabilities where you could bring discredit upon the employer in the eyes of other folks in the industry. And most importantly, and what you want to really avoid, is discredit in the eyes of potential clients or customers, So it is a responsibility of information security personnel to do everything in their power to deter unethical and illegal acts by the use of policy, education, training, and technology as controls or safeguards to protect the information and system. So how do we deter unethical or illegal behavior? Well, many security professionals understand quite well technological means of protection. And we have a couple courses in our curriculum that address that really well. They talk about how are we technically going to protect our resources. But many people underestimate the value of policy. There are 3 categories of unethical behavior that organizations and society should seek to eliminate. Ignorance, accident, and intent. So some things occur just because people are ignorant. Some things occur just by accident, and some things occur because people have ill intent. So the idea of deterrence is to prevent an illegal or unethical activity. Examples of things that we use for deterrence include laws, policies, and technical controls. They're all different types of deterrence, but they're all functional. Laws and policies as opposed to technical controls. Technical controls will very often work just because the technology works. Okay? Laws and policies only deter if there are 3 conditions present. There's a fear of penalty, there's a probability of being caught, and a probability of a penalty being administered. So, and where any one of those is not true, then the law or policy probably fails to form a deterrence. The big deterrence on a lot of people is just knowing right from wrong. And this is, anybody know who that is? That's Crazy Cat, who was a comic strip character dating back over 100 years. And Crazy Cat here is saying, "Oh, what a boons it is indeed to have a great moral sense. Oh, what a gift it is to possess that wonderful neck of knowing right from wrong." Crazy Cat spoke fractured English, always. But not everybody can do that, and that's why education becomes important. How do we know as professionals what constitute expected standards of our profession? Well, we have that through certifications in professional organizations. Many organizations have codes of ethics or codes of conduct and or codes of ethics. And some organizations have both a code of conduct and a code of ethics. Okay? Codes of ethics have been shown to have a positive effect. Okay? Because they do lay out some fundamentals of standards for people for whom it might not be immediately clear what the expectations are. Unfortunately, having a code of ethics is not enough. Security professionals have to act ethically and according to the policies and procedures of their employer, their professional organization, and the laws of society. I'm a member of several professional organizations, and some of them, I would say I take the code of ethics pretty seriously. One that I'm a member of, a longtime member of, is the Association of Computing Machinery. I actually have been the chapter advisor here at IIT in the past. This is a respected professional society. It was established in 1947 as the world's first educational and scientific computing society. And the ACM Code of Ethics, it requires members to perform their duties in a manner that befits an ethical computing professional. The code contains specific references to protecting the confidentiality of information, to causing no harm, to respecting the privacy of others, and to respecting the intellectual property and copyrights of others. ACM SIGITE, the ACM Special Interest Group in IT Education, is the leading professional organization for IT educators. I happen to be a national committee member of ACM SIGITE. So, I'm pretty involved in this, and quite a few of our faculty members are members of ACM. It's a good organization. Another organization is the International Information System Security Certification Consortium, or ISC squared, because they're IISSCC. They are a nonprofit organization focused on the development and implementation of information security certification and credentials. They have a code of ethics that's designed for information security professionals who've earned a certification from ISC squared. Their code focuses on 4 mandatory canons. It goes into a little more depth, but these are: protect society, the Commonwealth, and the infrastructure. Act honorably, honestly, justly, responsibly, and legally. Provide diligent and competent service to principals. And advance and protect the profession. They are the parent organization for the CISSP certification. The System Administration Networking and Security Institute, or the SANS Institute, is a professional organization with a large membership dedicated to protecting information and systems. They offer a set of certifications called the Global Information Assurance Certification, or GIAC. Their code of ethics requires respect for the public, respect for the certification, respect for my employer, and respect for myself. ISACA, which is ISACA.org, formerly the Information Systems Audit and Control Association, but now they're just ISACA, is a professional association with a focus on auditing, control, and security. The membership comprises both technical and managerial professionals. They have a code of ethics for its professionals and requires the same high standards for ethical performance as other organizations and certifications. And I already said that. ISACA is the home of the Chief Information Security, the Certified Information Systems Auditor certification, and the the Certified Information Security Manager certifications. I got to get those right, as well as the IT Governance Institute. Oops. And their code of ethics says that members and certification holders will support the implementation of and encourage compliance with appropriate standards, procedures, and controls for information systems, will perform their duties with objectivity, due diligence, and professional care in accordance with professional standards and best practices, will serve in the interests of stakeholders in a lawful and honest manner while maintaining high standards of conduct and character, and not engage in acts discreditable to the profession, maintain privacy and confidentiality of information obtained in the course of their duties unless disclosure is required by legal authority, and such information shall not be used for personal benefit or released to inappropriate parties. Maintain competency in their respective fields, agree to undertake only those activities for which they can reasonably expect to complete with professional competence, inform appropriate parties of the results of all work performed, revealing all significant facts known to them, and support the professional education of stakeholders in enhancing their understanding of information systems security and control. I put that one in because it's the shortest one. Okay, but it lets you see, all that their particular code of ethics says. Pretty clear, pretty reasonable, and most of these are like that. The Information Systems Security Association, ISSA, is a nonprofit society of information security professionals whose primary mission is to bring together qualified practitioners of information security for information exchange and information educational development. They have quite a large Chicago chapter to which students in our program are always welcome at chapter meetings without, you don't even actually have to be a member. And sometimes there are fees, and I think unless the fees are paying for food or something like that, they're generally waived for students who attend ISSA activities. They provide conferences, meetings, publications, and information resources to promote information security awareness and education. And they promote a code of ethics similar to ISC Squared and ISACA and ACM. Promoting management practices that will ensure the confidentiality, integrity, and availability of organizational information resources. ACIS International is an umbrella organization for all aspects of security with equal emphasis on physical security, loss prevention, and now IT security. So they made it kind of a tripartite organization with an equal emphasis on each of those areas. Historically, for a long time, ACIS' primary focus was physical security and loss prevention, but they recognize that in many organizations there is what's the right term? That these activities are intermingled to the point where you can no longer adequately separate them out. Certifications from ACIS include Certified Protection Professional, Certified Investigator, and Physical Security Professional. They have a very strong, simple code of ethics. AITP, which is now CompTIA AITP, is the community of IT knowledge focused on empowering the IT profession by evolving its members to their full potential as a professional. They have a code of ethics based on six obligations to stakeholders to which IT professionals are bound. Management, fellow members, society, their educational institution, their employer, and their country. 6 obligations. Let me just say something about AITP. One of the things that they did when they merged with CompTIA, the Computer Trade Industry Association, is that student membership in AITP is now free. So everybody should join. Just go to AITP.org, go and become a student member. And one of the things that it does get for you is if you ever want to take any CompTIA certifications, like A Plus or Network Plus or Security Plus, you get 50% off. Okay, just by being a student member. And student membership is free. So it's a really good deal. I advise everybody to do it. Again, a lot of the faculty members are AITP members as well. I'm an AITP member, Dr. Carlson, Louis McHugh. A fair number of us are also AITP members. One of the benefits and one of the reasons they can do this is because CompTIA is a nonprofit, but they do certifications. And last year, they made $65 million from their certifications. And because they're a nonprofit, they have to do something with all that money. So a lot of the money from certifications are now going to support activities of AITP. So they also fund some scholarships. So there's a lot of opportunities through what is CompTIA AITP. The Internet Society, or ISOC, is a nonprofit, non-governmental, international professional organization that promotes the development and implementation of education standards, policy, and education and training to promote the Internet. There was at one time a Chicago chapter of the Internet Society. The former president was trying to see if there were student interest in maybe jump-starting it and getting it restarted. I don't know where that stands right at the moment. The Internet Engineering Task Force is an organization under the Internet Society. It consists of individuals from computing, networking, and telecommunications industries who are responsible for developing the technical foundations of the Internet. Standards that they determine are reviewed by the Internet Engineering Steering Group with appeal to something called the Internet Architecture Board, and then are promulgated by the Internet Society as international standards. We're also going to, as we're touching on professional organizations, we're going to touch on some of the agencies of the federal government that deal directly with you as cybersecurity professionals. One of the key ones is the NIST Computer Security Division. That is the Computer Security Division of the National Institute for Standards and Technology. They run the Computer Security Resource Center, which is an essential resource for anybody who is either a practicing or aspiring information security professional. They're involved in 5 major research areas that relate to information security, cryptographic standards and applications, and many of the standards for cryptography are published by NIST, security testing, security research and emerging technologies, security management and guidance, and outreach, awareness, and education. Associated with them, we have the CERT Coordination Center, or CERT-CC. This is a center of Internet security expertise that's part of the Software Engineering Institute, which is a federally funded research and development center operated by Carnegie Mellon University. They study security issues, and they provide publications and alerts to help educate the public to the threats facing information security. They also provide training and expertise in the handling of computer incidents and act as both a research center and an outside consultant in the areas of incident response, security practices, and programs development. And for those of you who are not aware, probably most of you, because he's been around a while now, the president of the university, before he came to IIT to be the provost, was at Carnegie Mellon University. So that's why he arrived here with a much better understanding of what we do than the previous folks we've had. He immediately looked around and said, "Oh, ITM, you guys are doing things that make a lot of sense." Computer Professionals for Social Responsibility is an interesting professional organization. It is a public organization for technologists and anyone with a general concern about the impact of computer technology on society. They promote ethical and responsible development and use of computing and seek to inform the public and private policy and lawmakers on this subject. They act as an ethical watchdog for the development of ethical computing. Another key federal agency is the FBI. At one time, they had something called the National Infrastructure Protection Center, which was the government's focal point for threat assessment and warning, which was integrated into the Department of Homeland Security in 2004, and is now called the National Infrastructure Coordinating Center, which is half of the old function, and the United States Computer Emergency Readiness Team, or USCERT. So those are some important agencies that had been under the FBI that are now under the Department of Homeland Security. What's still under the FBI, and this is a significant organization, is the National InfraGard program. This is a key part of the FBI's efforts to educate, train, and involve the business and public sector in information security, because every FBI field office has an InfraGard chapter, and they collaborate through this chapter with public and private organizations and the academic community to share information about attacks, vulnerabilities, and threats in the greater cybersecurity realm. One of the points of the InfraGard program is to provide free exchange of information to and from the private sector about threats and attacks on information resources. The Internet Crime Complaint Center is another federal program. It is a partnership between the Federal Bureau of Investigation and the Department of Justice's National White Collar Crime Center. It's a vehicle that's intended to receive, develop, and refer criminal complaints regarding cybercrime. The idea here was to give victims of cybercrime a convenient and easy-to-use reporting mechanism to alert authorities of suspected criminal or civil violations, particularly criminal violations that may be subject to prosecution under federal law. Here's an interesting question. In order for a federal prosecutor to prosecute someone for cybercrime, generally there has to be a demonstrable financial loss stemming from the crime. So, does anybody know the number? I just saw somebody, so I know somebody knows the number. There's a number, generally a floor, beneath which they won't go to prosecute somebody. Anybody know it? Yeah? Yeah. What? No, not $50.
About 10,000.
No.
I know what's not 50.
$50,000. So I'm not saying go out and commit $49,000 computer crimes, okay? Don't anybody misconstrue this. Okay? But the fact is that generally computer crimes that have don't reach the floor level of demonstrable loss are not going to be prosecuted by federal prosecutors. Now, in Illinois, we have an interesting infrastructure because we have the Illinois computer crime statute that we talked about earlier, and in some cases, the Attorney General's office or state's attorney will prosecute for computer crimes of lesser magnitude under Illinois statutes rather than federal statutes. So it's just, how well how good a case can you present? Cyber crimes are difficult things in courtrooms. So that's another reason why there's not the level of prosecutions those of us who have dealt with cyber crimes over the years would have hoped to see. The National Security Agency is the lead cryptologic organization for the government. It is an agency of the Department of Defense. They coordinate, direct, and perform highly specialized activities to protect U.S. information systems and produce foreign intelligence information. They are responsible for signal intelligence and information system security. Right now, the director of the National Security Agency is also the commander of the United States Cyber Command, and apparently they are going to split those out so that the U.S. Cyber Command, which is a military command comprised of principally military personnel, will be split off from the NSA. And it's not part of the NSA now, it's just they have the same person in charge. So they'll separate out those responsibilities. The Information Assurance Directorate at NSA provides information security solutions, including technologies, specifications and criteria, products, product configurations, tools, standards, operational doctrine, and support activities needed to implement the protect, detect, and report and respond elements of cyber defense. They run cybersecurity academic and research programs through their National Centers of Academic Excellence program. And I now know most of those people. I've met most of those people because I'm the principal for us as a National Center of Academic Excellence in Cyber Defense. And so I get to go to these conferences that they pay for. So, and one of my absences from class this term, where I will have the lecture online, will be because I will be at a National Center of Academic Excellence meeting in Ohio, somewhere in Ohio. I should remember, but I'll be in Ohio, meeting with the feds. The United States Secret Service also has some cyber activities that they're involved with. They, of course, protect key members of the U.S. government, but they also are the folks responsible to detect and arrest any person committing U.S. federal offenses relating to computer fraud and false identification crimes. So when people are making use of computer systems for fraudulent activity and for false identification crimes, they are responsible. And the Patriot Act increased the Secret Service's role in investigating fraud and related activity in conjunction with computers. The Department of Homeland Security was established. See, this is what a public law looks like before it becomes part of the Code of Federal Regulation. The United States Code. They were established by Public Law 107-296, which transferred the Secret Service from the Department of Treasury to the Department of Homeland Security. Department of Homeland Security has some very serious cyber security responsibilities. However, for a long time, they failed their FISMA-required information security audits every year until 7 years ago they got a D. 6 years ago, they got a B, and since then, they've been a B or better. But it took them a long time to internally get their act together for cybersecurity, and yet they're supposed to be the people that are running a lot of cybersecurity efforts of the federal government. The Office of Cybersecurity and Communications is a major office within the Department of Homeland Security, which is a home to the National Cybersecurity Division, the National Communications Division, and the United States Computer Emergency Readiness Team, U.S. CERT. Now, the federal government, of course, as we discussed, is bound by FISMA, the Federal Information Security Management Act, and one of the congressmen started looking at their returns and giving them a letter grade. So a lot of federal agencies got letter grades. The U.S. government as a whole had a C grade in 2007, which was up from a C minus in 2006 and a D in 2005. But the Department of State had a grade of C, up from an F in 2006. Department of Defense had an F in 2006, was up to a D minus. The Department of Justice moved from an A minus to an A plus, so somebody was doing the job right. The Department of Veterans Affairs had an F in 2005, didn't submit a report at all in 2006, and had another F in 2007. And the Department of the Interior and the Nuclear Regulatory Commission each earned an F. That's pretty scary that the Nuclear Regulatory Commission failed their inspection. Has it gotten better? Yeah. But in 2015, the U.S. government had a grade of D. Okay. It was heavily affected by some new scoring methodology that made it a little bit tougher. But the Department of State had a grade of F. The Department of Justice moved from their A down to a B. The Department of Veterans Affairs, with an F in 2007 and a B in 2014, still managed the C. 7 agencies, however, received an F. And the General Services Agency received the only A. The Department of Defense failed to turn their reports in. So we don't know how the Department of Defense did. And grades weren't compiled like this for 2016, so I can't tell you what they were in 2016. The most recent FISMA report, however, which covers fiscal year 16, from the Office of Management and Budget, is available on Blackboard if you want to see, what the report looks like. Let's talk about some other legal issues here. Organizational liability and the need for counsel. What if an organization doesn't support or even encourage strong ethical conduct on the part of its employees? What if the organization itself doesn't behave ethically? If an employee acting with or without authorization performs an illegal or an unethical act causing some degree of harm, the organization can be held financially liable. Okay? This is liability, and it's an important legal concept to understand. Liability is the legal obligation of an entity. Liability extends beyond legal obligation or contract to include liability for a wrongful act and the legal obligation to make payment or restitution. So liability can be applied to conduct even when no law or contract has been breached. Okay, so liability doesn't necessarily mean that a law has been violated. An organization will increase their liability if they fail to take a set of strong measures known as due care. Due care means that we've established a standard that says that we are, on a day-to-day basis, engaging in activities that would normally be expected of a similar organization. So in cybersecurity, when we talk about due care, we're talking about having established standards for cybersecurity within an organization through policy, through procedures, through technical controls. Okay, that's due care. If you have a standard of due care in place, due diligence requires that the organization make a valid and ongoing effort to protect others and continually maintain this level of effort. So you can have due care without due diligence, okay? You have to have both. You have to have a standard of due care, and you have to exercise due diligence. These are both important legal concepts and would be very good things to ask on an exam. So kind of important to understand concepts of due care and due diligence. Jurisdiction is a court's right to hear a case. Any court can impose its authority if the act that is being considered was committed in its territory or involve its citizenry. And sometimes in computer security, we have something referred to as long-arm jurisdiction. What does that mean? Well, it means that someone may commit a crime in California and they're tried for that crime in Tennessee. And in fact, that actually happened. There was a computer bulletin board system that was publishing what was considered to be material that was obscene by Tennessee standards and could be accessed by people in Tennessee even though they were in California. So the people who ran it were tried for obscenity under Tennessee laws and were found guilty. So that's long-arm jurisdiction. That happens because of the nature of legal jurisdiction. Let's talk about a little bit more about law, ethics, and forensics. And forensics in this instance, we're talking about investigation of computer security breaches or investigation of basically anything that's going to be used as evidence. Okay, we have ITMM 485, 585, legal and ethical issues in information technology. That is taught in the spring. I'm teaching it this spring, 2018. I'm teaching it in the spring of 2019. And in the summer of 2019, I'm going to teach it in the study abroad program, hopefully in New Zealand. So if you want to take that course in New Zealand and you're still going to be around in the summer of 2019, you might go, well, I'm going to wait till Professor Trigstad teaches that in New Zealand. That's going to be fun for everybody, you know. So I'm the one who teaches that. ITMS 538 Cyber Forensics is our course that teaches people how to properly conduct a forensic investigation of a computer security incident or anything in the realm of computing that requires the presentation of evidentiary material. We also have ITMS 584, Governance, Risk, and Compliance. Next week, we're going to talk quite a bit more about governance, risk, and compliance. And that's just what that course covers, is security governance, which is the implementation of security at the level of organizational governance, which is board of directors for a corporation or the board of governors or the board of trustees for an academic institution. Risk, of course, is managing risk, and compliance is complying with the law. A lot of what we talked about in this lecture is going to be addressed in considerably more depth in that particular course. ITMS 588, Incident Response, Disaster Recovery, and Business Continuity, has a lot to do with legal responsibilities for an organization in attempting to continue the organization's operations when things are disrupted in major ways. And all of those courses are typically offered in the spring. So all those courses are normally spring courses. I apologize for the fact that this lecture jumps around a little bit. I had one slide out of order. That's really stupid. I'm sorry. Somehow I don't even know how it got there. But apart from that, it does jump from topic to topic. And one of the reasons is, and you'll see this in some of the other lectures, there's a lot of topics that need to be covered over the course of the lecture. So consequently, if I had sufficient time, I would try to write it so it all flowed together a little more smoothly and had nice transitions. And someday I hope to do that, but I don't know when I'm going to get that done. So that does bring us to the end for tonight. Are there any questions? I will be available for a few minutes tonight. I don't have to run to catch a bus today because I had to drive today because I had a medical appointment, so I could do my surgery on Tuesday. Tuesday, by the way, I'm having surgery on my birthday, and people said, "Why are you doing surgery on your birthday?" And I said, "Oh, because I get the rest of the day off." So, not really the best way to get a day off, mind you, but yeah. What? Sign-in sheet. I didn't bring it today. So you guys all get a bye.
Oh no, that one guy's going to get extremely angry.
So,
Can't remember what his name is.
but
Professor Tracy,
yeah.
can I bring my outline to you Thursday?
To look at before it's due?
Yeah.
Sure. Yeah, I'd be happy to look at it.
Are you always at your office hours on Thursday? On this
3 to 5. Always, yeah.
Okay.
Yeah. Sure, I'd be happy to. Yep. Let's see. So I have to say you are successfully progressing. You were in attendance.